Okay, contracts, part 1. On the exam, apply common law unless the question or fact pattern is for a sale of goods or the predominant purpose of the contract in question is for goods or services. You have to determine the predominant purpose. If it's for goods, apply UCC. Formation of a contract requires mutual assent, that is, acceptance of a valid offer. These facts are interpreted by a reasonable person. So facts as interpreted by a reasonable person. This is the objective theory of contracting. An offer is a manifestation of willingness to contract. It gives power to the recipient to conclude the contract by acceptance. Looking at the intent of the offer is interpreted from the offeree standpoint. The offeree reasonably interprets it as an offer, and it's an offer. It has to express a present intent to contract, means they want to contract now. Knowledge of an offer, the offeree must have knowledge of the offer to be able to accept it. Looking at terms of offers. Under the common law, all essential terms must be included. That's essential terms such as parties, subject matter, financial terms, etc. Under the UCC, if the intent to contract is shown and the term is missing, the UCC, quote, fills the gap, end quote, where the contract is silent on a term. The UCC therefore maintains the intent to contract. Looking at the duration term of the offer. If the duration term of the offer is not defined, then it is a reasonable term. Under an employee contract, there's a rebuttable presumption of at will. There's no where the contract has no duration or uses the language of, quote, permanent, end quote, that is considered an at-will contract. Where an employment contract uses the term, quote, lifetime, end quote, jurisdictions are split on to whether that results in a rebuttable presumption of at-will or a lifetime contract. On the exam, when a question in regards to employment agreement arises and that is not at will, use a breach of contract analysis. Where there is a missing term in an offer, where the parties do intend to contract, the presumption is that the parties intended to include a reasonable term. The court will supply one, but must have an objective standard for reference. Now this, where there is a vague term, that's not a missing term, a vague term, this presumption cannot be made. So this presumption cannot be made as a vague term. The court cannot supplant a vague term with a different term because intent cannot be determined. Looking at the language of offers, where the offer requests a return promise, that is a bilateral contract, such as I promise to do X if you promise to do Y. Where the offer requests a return act, so, that is a unilateral contract, such as where I will pay you X amount of dollars if you paint my fence. Invitations to deal as offers, these are advertisements. They are invitations to receive offers from the public. They are generally not considered offers. However, where the invitation to deal or the advertisement has greater specificity, there is an increased likelihood that it will be considered an offer. Lapse in time resulting in termination of an offer, where an offer states that it terminates on a specific date, it terminates on midnight of that day. Where the offer states that it terminates after a number of days, the clock starts when the offer is received. Now, where no time is included, in the offer, then the offer is good for a reasonable period of time. Revocation, termination of an offer by revocation, where the offeror revokes the offer. An offer can be revoked by the offeror any time prior to acceptance by the offeree, even if the contract states it will remain open for a specific period of time. There is some difference in an option contract, which we'll discuss next. Revocation must be made in a reasonable manner and/or means. However, it is not effective until communicated, such as by mail, not effective until communicated. Or the offeree is aware that the offeror has taken an action, a definite action, inconsistent with the offer. Now looking at option contracts, termination of the offer by revocation. Again, the offeror revokes the offer. Where it's an option contract, we should discuss what an option contract is. An option contract is a promise to keep an offer open for a period of time. And an option contract may not be revoked until after that period expires. An option generally requires separate consideration, so you purchase an option, unless that option is included in an existing contract and that consideration of the contract is sufficient for the option as well. The open time of an option contract must be reasonable. Where it is not defined, in an option contract where the open period is not defined, the common law considers a reasonable period of time. The UCC states that it cannot be more than 90 days. Revocation, termination of an offer by revocation, where there has been partial performance. And this is in context of a unilateral contract. Again, a unilateral contract requests a return act. Where there has been partial performance of a unilateral contract, that contract cannot be revoked. Termination by revocation of an offer. Termination of an offer by revocation and the UCC firm rule. An offer to buy and or sell goods, again goods because we're under the UCC, is irrevocable if the offeror is a merchant, assurances have been made that the offer will remain open, and those assurances are in an authenticated writing from the offeror. However, again, as discussed in option contracts, irrevocability cannot exceed 90 days. And that ends part one of our discussion of contracts.